The prayer this afternoon will be offered by the good delegate representing Montgomery County.
Thank you, Madam Speaker. At a time in session when our patience with our colleagues across the hall may be wearing thin, let us contemplate the wisdom of our predecessors, who on this date in the year 1650 divided the General Assembly into two chambers. Borrowing a few lines from Buddhist teachings, may we all have patience, courage, understanding, and determination to meet and overcome inevitable difficulties, problems, and failures in life, especially when they involve the other chamber. Amen.
Amen. Quorum call.
Madam Speaker.
Nobody? Is everyone who's here recorded their presence? If not, the clerk will take the call. There being 123 members present, the House is still in session. And now in session. The clerk will read the journal from the previous day.
Annapolis, Maryland, March the 26th, 2023.
Recognizing the Deputy Majority Leader.
Thank you, Madam Speaker. Move so much be considered the reading of the journal.
So ordered. Petitions, memorials, and other papers. Yea and nay. Consent calendar 5. House bills passed in the Senate. The clerk will read the first bill.
House Bill 23.
Recognizing the Majority Leader.
Thank you, Madam Speaker. So much be considering HB 21 to be considered the reading of all the bills on the calendar.
So ordered. Yea and nay. Consent calendar 6. House bills passed in the Senate. The clerk will read the first bill.
House Bill 21.
Recognizing the Majority Leader.
Thank you, Madam Speaker. So much be considered the reading of HB 23 to be considered the reading of all the bills on the calendar.
So ordered. Report of the Committee on Health and Government Operations, report number 31. Clerk will read the first bill.
Senate Bill 399, Health Occupations Environmental Health Specialist, revisions, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk will read next bill.
Senate Bill 497, State Designation, State Spirit, Maryland Rye, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered passed for third reading. Clerk will read next bill.
Senate Bill 940, State Board of Pharmacy, accessible prescription label, bag tags, and medical guidelines for blind, visually impaired, and print disabled individuals. Regulations, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk, read next bill.
Senate Bill 960, State Board of Nursing, Sunset Extension, Licensure Exceptions, and Board Operations and Membership, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. Favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered past the third reading. Clerk, read next bill.
Senate Bill 965, Cancer Screening, Health Insurance, and Assessment of Outreach, Education, and Health Disparities, favorable.
Question for the House is the adoption of the favorable report. All in favor signify by saying aye. Opposed? The ayes have it. The favorable report is adopted. Are there any amendments to the bill or to its title? Hearing none, the bill is ordered passed for third reading. House bill amended in the Senate. House Bill 550. The clerk will read the bill and the Senate amendments.
House Bill 550, Maryland Energy Administration, Energy Programs, Modifications, Clean Transportation and Energy Act, Amendment Number 1.
Recognizing the committee chair.
Thank you, Madam Speaker. We move not to concur.
The motion before the House is to not to concur in the Senate amendments. All in favor signify by saying aye. Opposed? The ayes have it. The amendments are rejected. The clerk will read the message to the Senate.
Ladies and gentlemen of the Senate, the House of Delegates refuses to concur in the Senate amendments and respectfully requests the Senate recede from its position. Should the Senate prefer a conference committee to confer on the disagreeing votes of the two houses, the House appoints Delegate Barvey chair, Delegate Stein, and Delegate Love. Said bill is returned herewith.
Quorum call.
Madam Speaker.
Has everyone recorded their presence? Clerk will take the call. There being 132 members present, the House is still in session. Calendar of third reading, Senate Bills number 49. Clerk will read the first bill.
Senate Bill 61, Property Tax Credit, Public Safety Officer.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, Senate Bill 61, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 139, State Police Retirement System and Law Enforcement Officers Pension System, Deferred Retirement Option Program, alterations.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There will be 135 votes in the affirmative. Senate Bill 139, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 363, Video Lottery Terminal Proceeds, Purse Dedication Account, Ocean Downs Racecourse Operating Loss Assistance.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, Senate Bill 363, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 414, Commission to Advance and Strengthen Firefighting and Emergency Medical Services within Maryland.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 135 votes in the affirmative, Senate Bill 414, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 493, Commission to Study Trauma Center funding in Maryland.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There are 136 votes in the affirmative. Senate Bill 493, having received a constitutional majority, is declared passed. Calendar of third reading, House Bills number 100. The clerk will read the first bill.
House Bill 204, Maryland Aviation Commission, Duties, Composition, and Member Orientation.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 132 votes in the affirmative, Senate Bill 204, having received a constitutional majority, is declared passed. Clerk, read the next bill.
House Bill 760, Maryland Legal Services Corporation, Affordable Life, Wills, and Estate Planning for Seniors Grant Program.
is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 129 votes in the affirmative, Senate Bill 760, having received a constitutional majority, is declared passed. Clerk will read the next bill.
House Bill 1064, House Amenity Rentals, Sales and Use Tax imposed and local tax authorized.
It's on third reading and final passage. Is there any debate?
Madam Speaker.
Gentleman from Anne Arundel.
Thank you, Madam Speaker. Just to say a couple quick things on this bill that I didn't say this morning. One of the things that I realized when I went back to my office, and I know it really doesn't apply yet, but I'm sure it will. This morning we got a great prayer from the delegate from Baltimore City about the Orioles, and I recalled when I used to go to Oriole and Baltimore Colts game, we used to have to park in people's front yards, and we pay them cash. We now have a Preakness every year. I don't know how any of you remember Preakness as you were growing up, but we'd have kids show up around your car and say, please park in my front yard. Use my driveway. We'd pay them cash. They'd get your stuff to the gate for you. We start passing these kind of sweeping legislation to tax everybody, because I can guarantee you driveways are in this bill. They just don't have a governing authority to help tax it yet. We keep passing this stuff, I promise you. Some of these young kids just trying to make a living, having people park in their front yard, will be taxed this or fined in the near future. With that, Madam Speaker, I urge this body to vote against this piece of legislation.
I guess the floor leader.
Thank you, Madam Speaker. I will keep this quick. I think we've spent enough time discussing this bill by now. I will just say that this does not apply to casual sales. If you look at page 2 and page 3 of this legislation, you can clearly see that that is the case. So I hope that the body votes on this bill based on its merits and not any misconceptions that have been created. Thank you.
Gentleman from Anne Arundel.
Word in response would be yet. Thank you, Madam Speaker.
I didn't hear what he said. Any further debate?
Madam Speaker.
Gentlelady from Baltimore County.
Thank you, Madam Speaker. Will the floor leader rise, please, for a couple questions?
Yes, ma'am.
Floor leader.
Thank you so
Madam
much. So we know after the debate we had this morning, this bill will impose, is enabling, right? So it will allow my county, Baltimore County, to charge a 6% sales tax on the rental of a backyard swimming pool. Is that right?
No, ma'am. This legislation, it has the states and the statewide sales use tax component of this, right? And then separately, it authorizes your county to set a certain tax, right? It does not set a 6% local sales tax in addition to the state tax.
So this puts a 6% state tax plus a county tax, if they choose to do so.
Yes.
Okay, so I have a friend who actually started doing this last summer, and they're a young couple, and they have young kids, and it really helps pay for the maintenance of their pool. So if they don't know about this bill, I mean, certainly I will tell them, but let's say they weren't friends with someone here, and they didn't know they were supposed to collect 6% plus whatever the county determines. How would they know that, and what is the penalty for them not submitting this tax?
Are they renting out the pool through an online intermediary platform?
Sometimes yes, sometimes they do it themselves.
As is stated on page 2 and page 3 of the bill, if they are conducting this transaction through an official online platform, the consumer is going to pay that tax.
So what if they don't?
The platform is going to require that tax be paid, just like how it's required when you rent out a home through Airbnb.
So are we saying people that do this without that app don't have to pay it?
Yes.
Really?
Page 2 and page 3 of the bill.
Wow, so we're incentivizing people to not use the app and just rent the pool out themselves. Okay, this is good information. Is that what you said?
There's no question there. I'm sorry. That is page. This bill specifically applies to online intermediaries for the rental of home amenities. That is the extent of what this bill applies to.
So I'm looking at the bill. Which page again?
Page 2 and page 3.
Page
It
2 and
defines
3. So this bill only applies to an app that you would use to rent your swimming pool or bocce ball court or whatever. But
Yes.
if you happen to do it yourself, you don't have to pay it.
outside the scope of this bill. Does not apply.
Seems kind of arbitrary, I must say, that you're doing it this way. But all right, good to know. Who wanted it? The app company who came in and I saw Swimily had a submitted testimony.
They testified in favor of it because they want to be in line, and so did the Association of Counties, right? They want they want this industry to be in line with the rental of lodging, right? They want to be in line with Airbnb, right? They want the industry, like I mentioned earlier today, this industry, this marketplace has evolved. And we have to make sure that the taxes and the regulations evolve as well to meet what has become a new marketplace of home sharing.
So is it going to drive some of this underground? And then the state will come looking for them for the tax?
No, Delegate, right now it is underground because there is no official tax or regulation on these transactions.
Yes, but by taxing, what you said is the tax, obviously it's a pass-through tax. So, they're taxing the user, not the people that own the pool, but the people who rent the pool pay the tax. But you said if you rent your pool on the side and don't use an app, you won't have to charge people 6%.
Yes.
Okay. Sounds interesting. I'll be voting red on this. Thank you.
Is there any further debate?
Thank you, Madam
Speaker.
Speaker. It's Chairman. It's the Chairman.
Gentleman from
Thank
the
you, Madam
Calvert.
Speaker. Thank you. So I'm not actually sure it's legal to treat one group that has a platform for renting different from another. Probably isn't, which is why I'm quite certain that the comptroller, as my good friend from Baltimore County indicated, is going to come knocking on your door when you dare to rent out your pool or your tennis court or your bocce ball court. And so we all know that that's coming. And I'm pretty sure you don't need to pass legislation to close the loophole, as the majority party often says. But I was thinking about this when I went back to my office as well. And I realized, years ago we had a rain tax, and the citizens of the state didn't like that. And I think you've pretty much outdone yourself this time, because now we have a fun tax. Congratulations. Thank you, Madam Speaker.
Is there any further debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 91 votes in the affirmative, wait a minute, how did I get this? It is a House bill. House Bill 1064. Yeah, I know that. Having received the constitutional majority, is declared passed. Clerk, read next bill.
House Bill 1189, Economic Development, Cybersecurity, Cyber Maryland Program.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 134 votes in the affirmative, House Bill 1189, having received the constitutional majority, is declared passed. Calendar of third reading, Senate Bills number 51. The clerk will read the first bill.
Senate Bill 191, Prince George's County Office of the Sheriff, Duties and Deputy Sheriffs.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. Are you here to explain your vote, or what are you standing for?
Yes, Madam Speaker. Yes, this is good to vote on, everybody.
Okay. I don't know what's going on here, what you did for lunch, but there being 136 votes in the affirmative, Senate Bill 191, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 379, Election Law, Ballot Processing and Reporting Procedures and 2024 Primary Date.
So on third reading and final passage, is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 100 votes in the affirmative, Senate Bill 379, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 396, Economic Development, Upper Shore Regional Council membership.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 137 votes in the affirmative, Senate Bill 396, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 452, Film Production Activity Income Tax Credit, Alterations and Maryland Entertainment Council.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 119 votes in the affirmative, Senate Bill 452, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 801, Economic Development, Cybersecurity, Cyber Maryland Program.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 131 votes in the affirmative, Senate Bill 801, having received a constitutional majority, is declared passed.
Madam Speaker?
Yes.
I could change my vote on 379 from green to red, please.
Any other vote change? Yes.
Thank you, Madam Speaker. On House Bill 204, I'd like to be recorded as a nay.
Any other vote changes? Okay. Calendar third reading, Senate Bills number 52. The clerk will read the first bill.
Senate Bill 162, Maryland Aviation Commission, Duties, Composition, and Member Orientation.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 132 votes in the affirmative, Senate Bill 162, having received the constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 263, Maryland Higher Education Commission, Access to Mental Health Advisory Committee, Establishment.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There have been 136 votes in the affirmative. Senate Bill 263, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 330, Public Safety, Law Enforcement, Body-worn Cameras, Body-worn Camera Appropriation and Financing Act of 2023.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 137 votes in the affirmative, Senate Bill 330, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 426, University System of Maryland Board of Regents Quasi-Endowment Funds.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 133 votes in the affirmative, Senate Bill 426, having received the constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 660, Office of the Comptroller, Taxpayer Advocate Division.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There be 137 votes in the affirmative. Senate Bill 660, having received the constitutional majority, is declared passed. Calendar of third reading, Senate Bills number 47. The clerk will read the first bill.
Senate Bill 290, Office of the Attorney General, Independent Investigations Division, Authority to Prosecute.
Is on third reading and final passage. Is there any debate?
Okay.
Madam Speaker.
The minority leader.
Thank you, Madam Speaker. I have an amendment at the desk. It is 213325/1.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. This bill is a fairly radical, in fact, a very radical, again, the way that I use the word radical, which means it is a clear departure from what we have always done. What we have always done in the state of Maryland is we have allowed criminal prosecutions of criminal defendants of all types, primarily, if not all exclusively, to be done by your elected state's attorneys in each political subdivision or jurisdiction of the state. That is the way it has been almost forever. Your state's attorney is elected by your citizens, and your state's attorney and their subordinates have the exclusive ability to prosecute criminals. The federal system is a little bit different. You have United States attorneys that have jurisdiction over certain things in the state or the district within which they operate. You have the Justice Department writ large out of Washington, D.C., who can bring charges of different types of defendants across the nation. But in Maryland, the state's attorney for Baltimore City prosecutes the criminals of Baltimore City, and the state's attorney for Prince George's County prosecutes the criminals, alleged criminals in Prince George's County, and the state's attorney for Allegheny County prosecutes the alleged criminals in cases in Allegheny County. What this bill does is for one particular type of criminal defendant, it removes that. Who is the criminal defendant? It's a law enforcement officer who has been implicated in an incident involving death or, I believe, serious physical injury or serious bodily harm, and that the Attorney General's office believes is criminally culpable therefore. For that one type of defendant, that one type of individual, we're going to change our whole system. We're not going to allow that defendant, that individual, to be prosecuted by the local elected state's attorney. You heard my friend, the chair of the committee, indicate that we have 24 elected state's attorneys. Many of us know some of them. Some of them used to sit here in the room with us. One of them used to sit right next to me last year, who's now an elected state's attorney. Many of you know them. The state's attorney for Prince George's County used to sit in this room. 23 out of the 24 of those elected individuals, Democrats, Republicans, conservatives, liberals, former politicians, career prosecutors from Garrett County to Ocean City, are against this bill. They believe that it takes away their authority, their constitutional responsibility, their elected role to prosecute crimes potentially committed by police officers in their communities, in their jurisdictions, in your communities, in your jurisdictions. You're taking that away from them, and you're investing them exclusively in the Attorney General's office. What the amendment does is it provides a 60-day window for your local elected state's attorney. This is not partisan. The elected state's attorneys in many of the jurisdictions represented in this room are, in fact, card-carrying members of the majority party. It is not partisan. What the amendment does is it allows a 60-day window from when the Attorney General's office conducts this investigation, which we've authorized them to do, and that's fine. They conduct an investigation, they issue a report, and they say, we believe that there is some reason to believe or some probable cause to suggest that a crime may have occurred here, that a violation may have occurred by the police officer, and they should be prosecuted. What the amendment does is give 60 days, which is not a terribly long period of time, for your local elected prosecutor of all political stripes to take that information and to make a charging decision. Once that elected official, your state's attorney, makes that charging decision, if they decide to charge, then they are in control of that prosecution. They've made a decision to do so. If they choose not to, at the end of the 60 days, then and only then can the Attorney General's office enter into the equation and say, we're going to get proverbially a second bite at the apple and exercise our own judgment as to whether charges should be filed. What does that do practically? I think it's extremely reasonable. What it does is it allows your local elected state's attorney's office to make that initial determination if charges are there, and if there are charges, what should be the nature of the charges? What should be the counts of the indictment? What can be proven actually in court? What can be sustained beyond a reasonable doubt? That is a decision that we should trust the people that our voters elected to make those decisions. We should trust them. We should trust them. Doesn't matter if it's Prince George's County or Allegheny County or Carroll County. I happen to like the state's attorney for Carroll County very, very much. He's a good man. I know that. And so that's all the amendment does. It doesn't say the Attorney General is forever removed from the process. It doesn't say that the Attorney General's office right to investigate has somehow been taken away. It simply says that we should follow the processes we followed, and we should trust our own local elected leaders to exercise their judgment first, give them 60 days to assess whether or not charges are viable, and if so, what the charges should be, and not allow the Attorney General's office to be the sole arbiter of that decision. Thank you, Madam Speaker.
Madam Speaker.
Chairman of the committee.
Thank you, Madam Speaker. I'd ask the body to resist this amendment. This bill is about the confidence that we have in the process. This bill is about what we want to see happen when really tragedy hits our communities. When police officers, through the actions that they take, we find ourselves with people who have died or have had serious bodily injury happen to them. We had extensive debates on this floor in 2021 on police reform, and we discussed these issues. And one of the things that was expressed over and over again is we needed to give people the confidence that the investigation was, at least the investigation at that point, was going to be independent. This takes that next step and says we want to make sure that the prosecution is independent as well, because it is in fact more efficient. It's better for our communities. It takes, even if there was a scintilla of doubt that there could be some kind of partiality or bias in a local state's attorney's office, it takes that off the table. And if we could eliminate even that little, we just talked about peppercorns in the committee, that scintilla, that peppercorn of doubt, if we can take that off the table, we are absolutely right to do so. What this amendment would do is create a system that no one else has anywhere across the country. It creates a system, a two-tier system, effectively for prosecutions, that will undermine the independence of investigations, and it will muddle the case. It's exactly what we don't want to have happen in these cases when police officers have gone too far. We want there to be clarity. We want the investigation to happen, and we want the prosecution to happen. And the point, I'll go a little further with respect to the minority leader. Over and over again, it's said, we want to make sure that this is in the hands of an elected official. Well, the last time I checked, the Attorney General of the state of Maryland is elected by the people of the state of Maryland. He's an elected official. He's elected by the people all the way across the state. And you know what we entrust him to do? We entrust him to go after Medicaid fraud. We entrust him to go after organized crime. We entrust him to go after environmental crimes. We entrust him to do an enormous amount of work, especially in part in our criminal realm. And so the experience is there. And for those reasons, I believe this would take a big step backwards from where we want to be when it comes to police reform and when it comes to what we want these investigations to look like from beginning to end. So I'd ask you to resist the amendment.
Madam Speaker.
Are you going to let him respond, the maker of the... Yes.
Thank you.
Maker of the...
I appreciate my friend using scintilla twice in a speech. That was really good. I haven't heard scintilla in a long time. That was good. I like that, scintilla. But peppercorns, you got them all in there. That's good. But I think, I think to an extent, not to bore you all with more legalistic terms, I think sometimes we assume facts not in evidence. We assume that all of these cases that the police officer has automatically done wrong and will prosecute them. And what we have found out, we have heard that they've conducted 25 investigations since we've extended this power. And that, in fact, there hasn't been a finding of police misconduct resulting in criminal charges in any of the 25 cases. The majority of those cases are from the I-95 counties, the large counties, vast majority. And so what I would suggest to you is that sometimes we're putting the cart before the horse. The Attorney General is exactly right. It's an elected official. Because I know what the amendments are, I think in a few minutes you're going to hear a counter argument about maybe we shouldn't have elected officials at all if we don't trust some elected officials, but we only trust other elected officials. So we don't trust elected state's attorneys, but we trust the elected Attorney General. And what we're really doing is deciding whose ox is being gored. We trust the Attorney General's office because we anticipate that they will reach a different conclusion than a state's attorney. Why would we assume that? I don't know. I don't think that that's what's happened. I don't think that's what's been the common experience in these matters whatsoever. I think that there's a very notable, very horrible case that I believe originated in Prince George's County of an individual being shot while I think still handcuffed, still restrained inside of a car. That is disgusting. It's disgusting. And that individual is, in fact, that police officer, hopefully now, I assume former police officer, is being prosecuted by the state's attorney's office for Prince George's County, as it should be. Because that individual looked at the facts and the law of the case and determined that there is no way to suggest beyond a reasonable doubt that what that officer did is abhorrent. It's horrible. No excuse for it. No justification. It is criminal. And the state's attorney seemed to be able to make that decision completely without having the Attorney General office tell them to do that or handle that case themselves. And so I appreciate the thoughts of my very good friend, who, as he knows, I have a tremendous amount of respect for, but I think that we're assuming facts not in evidence to suggest that the Attorney General's office is the ultimate arbiter of these things. I think what we're suggesting is that we think the Attorney General may sometimes reach a different conclusion. And what my amendment very intentionally does is it allows that safety valve to suggest that if your local elected state's attorney, upon a review of the facts, the evidence, the report compiled by the independent investigation office, I mean, that's a key word, independent. What does independent mean to you? Independent necessarily doesn't mean to me the elected Attorney General of the state of Maryland who has to win a primary in one of our political parties and may take a position that may or may not influence his future election. That's not independent. And so the state's attorneys, to me, they should have the first crack at these cases. They have a 60-day period of time within which to make that decision. If they make a decision that the Attorney General's office thinks is wrong in terms of saying we're not going to prosecute, the Attorney General's office retains the ability to then bring the case. That's all it does, and we think that it's a much better way to address these situations with giving respect to all levels of the system and giving respect to all local officials in this realm to have the opportunity to weigh in on some of these cases and decisions that are extremely significant. They're not just significant to the people involved, to the officer, to their family, to the victim, to their family. They're significant to our society and to our culture, and we think that the local state's attorney's office should at least have a real role in that process. Subject to further debate, move the amendment. Thank you, Madam Speaker.
Madam Speaker.
Gentleman from Anne Arundel.
Thank you, Madam Speaker. Will the floor leader please rise for a couple quick questions?
Chairman of the committee.
Good afternoon.
Thank you. It's good to see you. Can you tell me where my state's attorney came in on this bill?
She's opposed.
Okay, and I asked because, full disclosure, I did not support her in her campaign to run, but I will tell you, she has done an outstanding job. And I know I don't need to tell you this, when she came in 2018, she came in on the heels of a horrendous, tragic event, the Capitol shooting, and she handled every bit of it. Her office has been nothing but exemplary. And I've told her that. She has far exceeded any expectation I could ever have for her. So her opinion means a ton to me, and her opinion is the reason that I am going to support this amendment.
Madam Speaker.
Yes.
Madam Speaker. Yeah, I think she's all right. I have an enormous amount of respect for the state's attorney for Anne Arundel County, and people in this chamber know where I work, and I get that. And I would have respect for her whether I worked there or not, because she did do an outstanding job for the people of Annapolis, and she does do a great job for the people of Anne Arundel County. Here I represent the people of the 46th District of the great state of Maryland. And here I get the privilege, thanks to the Speaker of the House, to serve as the chair of the Judiciary Committee. And we have worked on these issues for years, and we're going to continue to work on these issues. And I do respect her opinion a great deal. Having said that, what we learned through the process, through police reform, I think still informs what we're doing here today, in that we need to make sure that not just the investigation, but also the prosecution of these cases is consistent and in one place. And we have operated under the current system now for maybe just a little under 2 years, and it has resulted in those 25 cases. No charges have come. There may be no charges that come in the future. It could be that the Attorney General doesn't bring any of those charges as well. But what we will know is that there will be that separation between the local state's attorney's office that does have those long-time connections with people in the police department. It is natural. It is what happens there. And it doesn't mean that they don't prosecute police officers for a variety of different crimes, not including crimes that don't include these things. It doesn't mean that they're automatically biased. What it does mean, in my mind, is that we have a responsibility on the statewide level to exercise the policy choice here. And the policy choice here, the right policy choice here, is to make sure that there is that independent approach taken by an elected person, elected by all the people of the state of Maryland, get that sometimes, of Maryland, who can make sure that they are looking at this, looking at fairly, looking at it objectively, and that's why I would ask the body to resist the amendment.
Any further debate? Gentlemen, still pushing your amendment? Yes. Okay. Question for the House is the adoption of the amendment. All in favor signify by saying aye. Aye. Opposed? No. Roll call.
Madam Speaker.
Is everyone recorded their vote? Is everyone out of the lounge? Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Recognizing the minority whip.
Thank you, Madam Speaker. I have an amendment at the desk. The amendment number is 283924.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
So again, just to lay the foundation for my amendment, there was a couple comments that were made that I think mean something. We heard scintilla. We heard independent, confident in the process, and most important, we heard long-term relationships. I want to say I do find it somewhat interesting that we would possibly have concerns with, let's say, somebody in Prince George's conducting this sort of prosecution. Let's say someone who is a former delegate in District 25 for 8 years, but yet we could move the prosecution to a former delegate at the Attorney General's office who is also a District 25 state delegate for 8 years. I would argue that they both have the same long-term relationships in that community as far as potential bias. So what my amendment does is eliminates all of the scintilla of concern by moving this to the state prosecutor's office. Because as we know, the state prosecutor is the most independent office that we have. It's a non-political office. Non-political. If any of us get in trouble, that's who would investigate us, that's who would potentially prosecute us. Not a local, state's prosecutor, this and that. So just to reiterate, the state prosecutor is the most independent body which this body can actually ask them to do these investigations. So with that, Madam Speaker, I move the amendment.
Chairman of the committee.
Thank you, Madam Speaker. I'd ask the body to resist the amendment. The Attorney General's office has the people already in place, and they already have the people who work on these issues. They have the experience dealing with serious violent crimes. They have the experience dealing with criminal organizations. They have the experience, again and again. Criminal organizations in this context, by what I mean is people who have themselves committed violent crimes. They know how to try these cases. The state prosecutor's office doesn't have any of that experience. And again, as I've mentioned before, I believe that the AG as a statewide elected official brings the credibility and brings the accountability that's necessary to have as part of this process. And so I ask you to resist the amendment.
Maker of the amendment.
Thank you, Madam Speaker. Mr. Chairman, if he wouldn't mind asking just a brief question. Thank you, sir.
Sure. Chairman.
Has the Attorney General's office ever prosecuted any of these issues before?
Have they ever prosecuted a police officer
so
for misconduct in office, or a police officer for the death of another person?
No, police officer.
A police officer? I don't believe that they have, but I do believe that they have prosecuted other people who have killed other people and have done it in an organized way.
Sure, thank you. So I believe it's fair to say that they don't have the experience to do this at all. They've never had the experience of prosecuting police officers. We're moving this to their unit. So I think the argument as to whether they'd be more fit for this over the state prosecutor falls flat. And I think back to the point about long-term relationships and even the scintilla of bias, I think the state prosecutor would be the best place to investigate police officers in this state. And for those reasons, Madam Speaker, I push the amendment.
Any further debate? On the amendment, all in favor signify by saying aye. Opposed? Roll call.
Madam Speaker.
Everyone recorded their presence. Clerk will take the roll. The amendment fails. Are there any additional amendments to the bill to its title? Gentleman from Hartford.
Thank you, Madam Speaker. I have a quick question for the chair.
Chairman.
Good afternoon.
Hey, sir. How are you?
Quick question. Great.
Quick question. So I was reading through the bill, and I know what deadly force is and serious bodily injury is, and those terms I'm pretty familiar with. There's a term that really jumped out, likely to result in death. Could you please explain what the legal definition of that is?
Injuries likely to result in death are injuries likely to result in death.
How do we determine that? How does a prosecutor investigate? What's the legal standard for that?
I mean, the legal, you know it when you see it. Having said that, the issue is, and that I'm sorry for being garish in the answer, but at the same time, I mean, the issue that we have struggled with for a long time is what is serious bodily injury in these contexts. We addressed that issue a little bit in police reform, but here, at that point in time, when you have to make the decision at the start of the investigation of whether the Attorney General should be able, or the Attorney General should be conducting the investigation or not. You have the kind of the facts immediately before you, and they have to make a judgment right there where if the person has injuries where they are in a very serious physical shape, they have serious conditions, they could be in a coma, they could have serious injuries where they've lost a lot of blood, they're likely to result in death. And starting the investigation at those first moments of the investigation are so important that we need to make sure that they're able to start at that point in time. And that's why we're using that in the bill. If they're already going to be there investigating the cases from that very early point, they need to, then they should also be able to prosecute those cases as well.
So we do a really great job in this body defining terms, and there's a term already in here on page 3, serious bodily injury, and that's a term defined in the law. Why do we create a new term that's not defined in the law versus just using the term serious bodily injury throughout the bill?
Because I think the critical difference here is that we're looking at that point in time right after this event has occurred. And in some cases, you might have a situation where a serious bodily injury might not be incredibly apparent at that point. You might not know what the serious bodily injury is, but they do have injuries because the person was shot or was in other ways assaulted by the officer that provides enough information at that point in time when they get there to determine whether or not that investigation should proceed.
And I don't mean to belabor the point, but when someone uses deadly force and causes serious bodily injury, that's that threshold. This is apart from that, from what I can read, and you're an attorney, you're much more educated at this, but this seems very much apart from the legal standard, because if it was serious bodily injury, we would just use the word serious bodily injury.
But we also think that by using these words, it is a higher standard than serious bodily injury. The whole idea has been, in the discussions that we've had, that in the most serious cases that we have, cases that result in death, or in this case, injuries that are likely to result in death, those are the cases that we want the Attorney General to look at. So in my opinion, it's that next level up, and that makes it more, and again, along with the temporal nature of what they have to deal with, I don't think we want to leave a scintilla of doubt in this case. And my goal now is to make sure that scintilla is now said as many times as possible in this debate. But thank you.
Thank you, Mr. Chair. I appreciate it. Madam Speaker, I have an amendment at the desk. Amendment 813-327-1.
Amendment number 1.
So much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. And in addition to the very large words that my former chair have taught me today, which I'm still not even sure what it means, there's another term that I taught during my 2 tours into the Judiciary Committee, and that was we do not want the judiciary to interpret the will of the General Assembly. Right? We need to be very clear and very defined in the powers that we are giving law enforcement, the powers that we're giving state's attorneys, the powers that we're giving the Attorney General. Right? We are writing the laws, and we need to be very clear and concise. And when we are, with all due respect, inventing terms that have no legal definition, that are not defined, that aren't even defined in the bill. And what's more puzzling to me is we already have a term for this. It's serious bodily injury. Right? That's a legal term, clearly defined in the law. Why would we not use a clearly defined term already in the law versus inventing a new term, throwing it in there, and letting people figure it out? Frankly, it's unfair. It's unfair to burden the Attorney General's office with an undefined term. And then if that term's undefined and they try to prosecute law enforcement on an undefined term, will that even hold up in court? We are actually, with this term, putting the Attorney General's office, even when they're rightfully trying to charge law enforcement, even if they're justified in charging law enforcement with misconduct by creating serious bodily injury, this term may get them off on a technicality because this term is clearly undefined. It's unfair to law enforcement, it's unfair to the Attorney General, And what my amendment simply does is strike the term likely to result in death from the bill. With that, Madam Speaker, I move the amendment.
Chairman of the committee.
Thank you, Madam Speaker. I'd ask the body to resist the amendment. And it's interesting. I'm asking the body to resist the amendment because now as I look at it a little closer, it actually expands in some ways, but it could be conceived to expand in some ways. But having said that, he wants to completely strike the language whether an injury is likely to result in death. And a lot of our back and forth in the conversation that we've had is that term is not incredibly well defined, and that we should have used the term serious bodily injury. If we had used the term serious bodily injury, that could be somebody lost an arm. They may not die, but they have a serious bodily injury. You lose a leg, you may not die, but it's a serious bodily injury. The idea here is that using these words, injuries that are likely to result in death, are a higher standard than a serious bodily injury, so that we don't expand to cases that don't result in the death of another person. There are people who would argue that we should go down that road, but what we're doing is we're trying to keep this narrow, and we're trying to respect, in fact, the rights of local state's attorneys in those lesser cases. And so for those reasons, I ask the body to resist the amendment.
Maker of the amendment.
I'll yield to the minority leader.
Thank you very briefly. So,
Minority leader.
Thank you, Madam Speaker. My friend, the committee chair, who decides that the injury that the victim incurred was likely to result in death? What if a state's attorney says, I don't think so. I think that the police officer, like you said, committed an act that resulted in you lost a limb. I don't think that's likely to result in death. It's my case. You don't have the case, Attorney General. And the Attorney General says, well, you lost a lot of blood and you were in the hospital for a couple days and maybe you slipped in and out of a coma and now you're fully recovered. I think that qualifies as likely to result in death. It's my case. Get out. Who decides that?
The Attorney General would make the decision as to whether or not the injuries were likely to result in the death of the person. That would be the process under the bill. That's the process under the current statute. And the reason for that is, again, you need to have clarity. Now, if 10 days later, 20 days later, it's determined that the person is actually going to live and the injuries aren't likely to result in the death, then they pass the case down to the state's attorney's office below, or in the county where it happened.
I mean, likely the investigation, at least is my understanding, we've now invested the Attorney General's office with the ability to do these independent investigations. The investigations are likely taking much longer than a 10 to 20 day recuperation period. They're frequently taking months, which happens in complex criminal cases, multiple witnesses, DNA, evidence standards, reviewing videotape, all that kind of stuff. And so that's my only concern. I think that our colleague from Harford County's amendment is well considered, because what it attempts to do is say, we don't want to create this unintentional situation where you now have what we would call satellite litigation and controversy and debate about the nature of the person's injuries. I can see criminal defendants filing motions in court to say, hey, the injury was not likely to result in death. The Attorney General's office does not have the ability to prosecute me. If they win, then I can see them creating crafty, I'm not a criminal defense attorney, but I know some crafty ones. And yeah, don't turn around and look at him. You know what I'm saying. I'll just say there's some crafty criminal defense attorney will say, well, I think now there's maybe been perhaps some element of double jeopardy that's accrued. Now, that doesn't really happen unless you've gone forward farther in the process. But to suggest that, well, now the Attorney General's office prosecuted me, and now I've made a motion and say, I'm going to kick your case out because, in fact, the injuries you sustained were not likely to result in death. It is simpler to say, in the most grievous, terrible situations, the situations that truly capture all of our attentions, police misconduct resulting in death, that those cases would inure to the Attorney General's exclusive jurisdiction, and all other types of cases would remain, not to be unprosecuted, but would remain within the decision-making authority of the local state's attorney. And that's, I think, all the amendment would do. I appreciate the opportunity to speak on it. Thank you, Madam Speaker.
Is there any further debate on the amendment? All in favor signify by saying aye. Aye. Opposed? Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. there any additional amendments to the bill to its title? Recognizing the gentlelady from Carroll.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment number 343-929-1.
Amendment number 1.
Thank you, Madam Speaker.
So much be considered.
So much be considered the reading of the amendment.
So ordered.
A theme today. We forget. Thank you. In 2021, we gave the Attorney General's Independent Investigation Division, the IID, the sole authority to investigate police-involved fatalities instead of the duly elected state's attorneys in Maryland's 24 jurisdictions. Now the Attorney General has come back to ask us to strip the constitutional authority of these same duly elected state's attorneys to exercise their discretion to decide whether or not to prosecute these cases. The Attorney General basically has given our 24 elected state's attorneys a failing grade because they have declined to prosecute the 25 referrals sent to them since 2021 by the IID. When questioned by members of the committees, the head of the IID refused to say which of these referrals should have been prosecuted, but used the fact that none of them were as justification for stripping local prosecutors of their authority. Isn't it only fair that the IID be graded on its performance in prosecuting these cases once we give them this power? This amendment will simply require the Attorney General come back before this body in 4 years and report how the IID has done with the power we've given them and be graded on performance before we reauthorize that power. If it turns out that the IID is not effective in doing the job, then maybe we ought to let the power to prosecute revert back to the folks who are duly elected in each of our jurisdictions and let them do the job that they've been doing for well over 123 years. That is my amendment, and I hope it'll be considered friendly. Thank you.
Chairman of the committee.
Thank you, Madam Speaker. I appreciate receiving the delegate's amendment. I'd ask the body to resist the amendment. Between now and 4 years from now, there's a sunset of a different kind. And whether or not you believe it at this point, and for our new members, they may not fully grasp it, but your term is for 4 years. The Attorney General's term is for 4 years. All of our terms are for 4 years. And that is where the people of the state of Maryland get to make these kind of judgments as to whether they support the performance of the Attorney General or not. Over and over again, I've heard, and honestly, with genuine respect, and the respect for the former minority leader of the committee that I chair, I hear over and over again about local elected state's attorneys. Well, we have a statewide elected attorney general, and that's who we're vesting this power in. I don't believe a sunset is necessary, and I'd ask you to resist the amendment.
Maker of the amendment.
Thank you, Madam Chair, and thank you, Mr. Chair. Madam Speaker, I'm sorry. I was thinking Chair. As I've been here for the past 9 years, we have put sunsets on many, many bills. And when we talk about duly elected, and yes, we all duly elected our state's attorneys. Our communities duly elected our state's attorneys because we put our trust in them. And I think it's very reasonable to give a time period to see how this new system will work, and if it isn't working, that we should go back to the way that has always worked. So for that reason, I press the amendment. Thank you, Madam Speaker.
Any further debate? On the amendment, all in favor signify by saying aye. Aye. Opposed? No. Roll call.
Madam Speaker.
Has everyone recorded their vote? Clerk will take the call. The amendment fails. Are there any additional amendments to the bill or to its title? Hearing none. Oh, it's on third reading, that's right. The bill is on third reading and final passage. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, clerk will take the call. There being 99 votes in the affirmative, Senate Bill 290, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 591, Labor and Employment, Non-Compete and Conflict of Interest Provisions, Application of Prohibition.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 103 votes in the affirmative, Senate Bill 591, having received a constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 667, Annual Corrective Bill.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change your vote? If not, the clerk will take the call. There being 134 votes in the affirmative, Senate Bill 667, having received the constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 877, Annual Curative Bill.
It's on third reading and final passage. Is there any debate? If not, clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 136 votes in the affirmative, Senate Bill 877, having received a constitutional majority, is declared passed.
Madam Speaker.
Yes. Gentlelady from Baltimore County.
Yes. My button wasn't working, and I missed Senate Bill 162 and Senate Bill 163, which was right behind it. Both should be green.
Okay, your slips go up. Gentleman from Baltimore County to the right.
Thank you, Madam Speaker. Oh, Senate Bill 591 to red, please.
Gentleman from Baltimore County.
Madam Speaker, both bills, House Bill 1189 and SB 801 to red, and 426 SB to red. Thank you.
Okay. Gentleman from Baltimore County.
Thank you, Madam Speaker. Vote change SB 290 amendment to red.
Gentlelady from Anne Arundel.
Thank you, Madam Speaker. Vote change SB 290 amendment 283924 from green to red.
Gentleman from Western Maryland.
Thank you, Madam Speaker. Vote change House Bill 204 from yay to nay.
Gentleman from Carroll.
Thank you, Madam Speaker. SB 591 to yay.
Any other vote change? Okay. Calendar of third reading, Senate Bill number 48. Clerk will read the bill.
Senate Bill 858, Firearm Safety, Storage Requirements, and Youth Suicide Prevention, Jalen's Law.
Is on third reading and final passage. Is there any debate?
Madam Speaker.
Recognizing the minority whip.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment number is 263328.
Amendment number 1.
Move so much to be considered the reading of the amendment.
So ordered.
Okay. So this bill largely deals with, where am I looking? Oh, anywhere. Okay. This amendment does two things. It defines unsecured firearm as a, and then it also talks about what's called a cable lock and a trigger lock. And the reason for the amendment is that in the bill it talks about someone having access to a firearm. And, but what it leaves out is that if a firearm has a trigger lock on it or it's otherwise inoperable, then we wanted to put that in the bill to ensure that there's no liability on the homeowner there. Because the purpose of those locks is to ensure that there's gun safety, which is the purpose of this bill, which we understand. So I hope that the body will see this as a friendly amendment, and I'm happy to answer any of the questions about it. Move the amendment. Thank you, Madam Speaker.
Recognizing the floor leader.
Thank you, Madam Speaker, and thank you for the amendment. And I ask the body to reject the amendment because the purpose of the bill actually is to protect unsupervised children and to prohibit the improper storage of firearms, period. If a child gains access to a firearm and unfortunately harms someone or harms themselves, we need to have some level of accountability with respect to the improper storage. If the child actually, as the amendment stands, it is a double negative, but I'll overlook that fact. But as the amendment stands, if there is a trigger lock or what was the other, a cable lock or a case or other protective device, perhaps the child or someone could still have access to it. Someone meaning the child or someone that is identified in the bill. That could be a problem because they could take that to school. The box, they could take the whole container to school. And then where would we be? Not only that, they could, again, the purpose of the bill is to not leave firearms laying around, to not leave them in an unsecured location, period. That is the purpose of the bill, to not leave firearms in unsecured locations. It's not the firearm that we are asking you to secure. It's not the individual mechanism of the firearm that we're asking you to secure. We're asking you to store it properly, put it away, not leave it out, because even if it's a trigger lock or a container that is sitting in front of a child and that child gains access to it, we're in the same boat that we would be in otherwise. So, body, I ask you to reject the amendment. We want to make sure Marylanders are storing their firearms safely and that we are not allowing children to gain access to them and that we are protecting our children and we are preventing suicide.
Maker of the amendment.
Thank you, Madam Speaker. And listen, I will tell you this. I have two small boys, and I too worry about gun safety in my house. I have parents that own a farm, and I swear they leave shotguns and other farm equipment out, and I have to remind them about that. But look, my amendment has two parts. We just talked about them. You're arguing that you're preventing a minor from getting access. Well, if the gun is locked in a case, I mean, how are you going to argue that that's access? If the gun is inoperable, how are you going to argue that that's not preventing suicide? This bill has an exception for antique guns that are potentially still operable. So these are very reasonable amendments to prevent child access and to prevent suicide because, again, you're going to have an inoperable weapon or inoperable firearm, or you're going to have a firearm that's locked in a box. How are you going to argue that's access to it? I got to be honest with you, the word access is very broad. I mean, access means in the same house. It's very broad. So this is narrow. It does not defeat the purpose of this bill, which is safety and preventing potential suicide, but also it makes it reasonable. So for all those reasons, I ask that this body move this amendment forward, and Madam Speaker, I push the amendment. Thank you.
Gentleman from Anne Arundel.
Thank you, Madam Speaker. Can the floor leader please rise for a few questions?
Yes.
Thank you. Good to see you.
Good to see you.
Walk me through what you mean by storage. Is this strictly about safes? Because not every Marylander has access or funds for safes.
Right. So in 4-104 of the criminal law article, we indicate what safe storage looks like. And give me 1 second and I'll get there. One moment, please.
Absolutely. Take your time.
Okay. So safe storage looks like this. It is where a child cannot gain access. Okay, so where a person knew or should have known that an unsupervised, minor has access to the firearm. And it reads like that because we didn't want to have to dictate exactly how one needed to store it, because you're right, economy can be a matter of, is a real thing.
So you're talking about like behind a locked, like a bedroom door or a closet door. So I don't like have locks on my bedroom or my closet door, but let's say I have a firearm and that's in a closet.
So we leave it up to the individual to some degree to have some level of knowledge as to what goes on in their home. Sure. Or, for instance, a question was, well, what if I'm asleep and I have my firearm next to my bed on the floor and my child wanders in my room and gets the firearm? Well, that's not proper storage, because one should reasonably know that a toddler could wander in their room and get their firearm. So the whole point is to have a knowledge of what the people in your home, and namely the children or the minors in your home, whether or not they would have access to it. If it means to you keeping it, locked away in a safe, if it means to you keeping it locked in a drawer, if it means to you, other mechanisms, the key is to not make it available in which a child would have access, a minor would have access.
Maybe you can help me with this. What would be like a legal threshold? Oh, I'm sorry, thank you. What would be like a legal, she's right next to me, so we know each other very well, so sorry. What would be like the legal threshold? I guess who would interpret that? So, like I said, I don't have locks on my bedroom doors or my closet doors, so let's say I had a rifle or a pistol. My daughter's 25 years old and gone, but let's say I had a rifle or a pistol, but it was stored in my bedroom, in my closet, right, where normally a minor wouldn't be, but they did go in there. They would technically have access to that firearm at that point, even though in my mind it was stored correctly.
Well, I don't believe rifles are included, but I understand what you're saying. Yeah. So let's say for purposes of the bill, if you had a firearm and you had it in that closet, so the court would make that interpretation, and they would look at the facts. Okay. And they would say, has your child ever gone in that closet before? Have you ever told them, go in my closet and get a tie, or go in my closet and whatever? Well, so that would establish that minor has access to that closet. And therefore, we would look then to see, or the court would look then to see, how did you store it in that closet where you knew the minor would go? You see, so it would be a fact-based. It would be all based on the court, and it would be fact-based.
And it's my understanding that these type of locking devices that are being talked about in this amendment are sold per Maryland state law with every firearm, correct?
I can't say correct on that one. I don't know.
Right. It's my understanding that that's the case. So it just seems to me if the court's going to make that decision that adding these type of devices to those firearms for safe storage based on the definitions and language of the bill and the potential court interpretation would make a lot of sense. Do you agree?
I don't quite agree, because what we didn't do and what we were careful not to do is to list each and every circumstance in which the storage would be considered safe, because we want the courts to do that. But what we want to do is give the court something to work with, and that is a standard. And that standard is where a person knew or should have known that the unsupervised minor would have access to the firearm.
Okay. I understand what you're trying to say. Has there, and maybe you don't know this, and if you don't, that's okay. Has there ever been, to your knowledge, a suicide or a crime committed with a firearm that has had one of these devices attached to it?
I don't know.
Okay, that's fine.
No, don't know.
What's that? Well, I would like to, I guess I say on the amendment, yeah.
Yeah.
On the amendment. Thank you very much also. I rise in support of the amendment. It's another barrier to access to young people who may hurt themselves or others. to put onto these firearms absolutely makes a firearm completely innocuous and inoperable. And again, based on the interpretation of what could be brought on by the courts and limited funds and availability for families to get what I prefer as a method of storing my firearms, which is safes and behind locked doors. Again, this amendment doesn't impede this bill in any way. It actually sets up another level of safety. I urge support for the amendment. Thank you, body.
Any further debate? The maker of the amendment.
So just to close this out, again, my amendment for those that are still listening is this would still require a cable lock on the gun, making it inoperable. Or it would require the gun to be locked in a case that prevents physical contact. No physical contact. This is a good amendment. It does not defeat the purpose of this bill, and I ask this body to move favorably. Thank you, Madam
On
Speaker.
the amendment, all in favor signify by saying aye. Aye. Opposed? Roll call.
Madam Speaker.
Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Senate Bill 858 is on third reading and final passage.
Madam Speaker.
Yes.
Oh.
Gentleman from St. Mary, we're voting on this bill.
Oh.
Okay. So that's for a little later, okay? Senate Bill 858 is on third reading and final passage. Clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote?
Madam Speaker, to explain my vote.
Yes, gentleman from St. Mary's.
Thank you, Madam Speaker. And I know that this bill has come several years, and really it's a policy decision that addresses a horrible incident and a shooting that took place in my district. And the bill, to the credit of the vice chair of E&T, when he carried it, eventually named the law, this bill after her, Jalen Willie. And today I just want to recognize in the gallery Jalen's mom, Melissa, her sisters, Aaron and Addison, who has advocated for the change almost immediately after the loss of her daughter. And there's no love like a parent has for their child, as so many of us know. The one thing about judiciary is, some stories people have the courage to share. I can't imagine telling them, yet alone living them, and they continue to tell them, really, in many instances, knowing inevitably that bill will fail. But eventually, the persistence does pay off. And while she'll never be whole again, I'm hopeful that this small wing gives her the confidence to continue telling her story and to continue to fight for the change so that no parent has to go through what she's endured. And I just want to recognize her, and that's why I'm agreeing on the bill.
Clerk will take the call. There be 100 votes in the affirmative. Senate Bill 858, having received the constitutional majority, is declared passed. Calendar of third reading, Senate Bills number 50. Clerk will read the first bill.
Senate Bill 293, corrections, incarcerated individuals.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 102 votes in the affirmative, Senate Bill 293, having received the constitutional majority, is declared passed. Clerk, read next bill.
Senate Bill 351, Maryland Legal Services Corporation Affordable Life, Wills, and Estate Planning for Seniors Grant Program.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 132 votes in the affirmative, Senate Bill 351, having received the constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 592, Surplus Military Equipment Reporting Extension.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There be 136 votes in the affirmative. Senate Bill 592, having received the constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 789, Sexual Assault Evidence Collection Kits, Preservation and Storage.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 138 votes in the affirmative, Senate Bill 789, having received the constitutional majority, is declared passed. Calendar of third reading, Senate Bills number 53. Clerk will read the first bill.
Senate Bill 37, Criminal Procedure, Expungement of Records, Waiting Periods, Redeemed Act of 2023.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 99 votes in the affirmative, Senate Bill 37, having received the constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 691, Home Amenity Rentals, Sales and Use Tax Imposed and Local Tax Authorized.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 94 votes in the affirmative, Senate Bill 691, having received the constitutional majority, is declared passed. Clerk will read next bill.
Senate Bill 783, Preservation and Reuse of Historic Complexes, Study and Extension of the Income Tax Credit for Catalytic Revitalization Projects.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change your vote? If not, the clerk will take the call. There will be 138 votes in the affirmative. Senate Bill 783, having received the constitutional majority, is declared passed. Special order calendar number 56. Clerk will read the bill.
Madam Speaker?
Gentleman from Montgomery.
Yes, on I believe it was SB 596. My finger didn't work. I'd like to be recorded in the green, please. Or it might be 592. I'll get the exact number and get my slip up.
Okay. Young lady from Prince George's.
Madam Speaker, I'd like to be recorded as well on SB 691 in the green. Thank you. My finger didn't work.
Gentleman from St. Mary's.
Thank you, Madam Speaker. A vote change on SB 801 to green.
Any other vote changes? Okay. Special order calendar number 56. Clerk will read the bill.
House Bill 430, Police Immunity and Accountability Act. Favor report is amended, adopted.
Recognizing the minority whip.
Thank you, Madam Speaker. I'd like to yield to the committee chair. I believe he has an amendment.
Committee chair.
Madam Speaker, there's an amendment at the desk. 183127.
Amendment number 1.
Who so much be the reading of the amendment?
So ordered.
The amendment makes a correction to the title of the legislation. Move the amendment.
Okay. Question for the House is the Move, huh? Adoption of the amendment. All in favor signify by saying aye. Opposed? The amendment has been adopted. Gentleman minority whip.
Thank you, Madam Speaker. I have an amendment at the desk. The amendment number is 653027.
Amendment number 1.
Move so much be considered the reading of the amendment.
So ordered.
As I understand it, this bill, as we just saw, has been heavily amended. It kind of came in as one thing dealing with a lot of different things, and now it's completely something else. I said very little there, as you see. So what my amendment does is the following. The time for filing an administrative charges for a police officer shall occur within 1 year and 1 day. And I move the amendment. Thank you, Madam Speaker.
Committee Chair.
I'd ask the body to resist the amendment. The amendment would seek to make a change in the structure of the police accountability process. We have that process is just now underway in different parts of the state, and for that reason, we haven't taken this issue up just yet at the Judiciary Committee. I'm sure it's something that we'll be looking at in years to come, but I'd ask the body to resist the amendment.
Maker of the amendment.
Thank you, Madam Speaker. If the chair wouldn't, I know it's up and down all day. If you wouldn't mind, sir. Thank you.
Hello.
What would be the reason not to require that administrative charges against a police officer, be brought forward within 1 year and 1 day?
I'd need to look at this in the context of the bill that was introduced, and there's a bill in the committee that is addressing this issue. The issues could range from when that year and a day starts, or is it when the misconduct is allegedly discovered? There are a lot of issues that go into this kind of a piece of legislation, and that's why, since it's part of that larger police accountability package, and we're trying to let that move forward and get its legs underneath it, that's why the committee isn't taking this up this year.
Okay, thank you. So here's what I'm going to suggest, that similar to any citizen of this great state or this country, although we're not talking about a criminal proceeding here, but everyone's entitled to a speedy trial. So imagine there would be administrative charges against one of the police officers. Imagine if you're the victim. So forget about the police officers for a second. Let's talk about the victim who's alleging these charges against the police officer. Why would we not want to bring justice to the victim? Not the police officer, the victim. That we're somehow not going to bring any charges against an officer. We're just going to let it kind of hang out there. I think that folks deserve better. There was 1 year in 1 day. I know it was a previous bill that was discussed that was never brought forward this year. I think that's what the chairman of the committee was alluding to. But I think this is an opportunity, again, to have justice on both sides, both the victim and the police officer. And that's why it's important to have a time frame in place. So for those reasons, Madam Speaker, I move the amendment. Thank you.
On the amendment, all in favor signify by saying aye. Opposed? Roll call.
Madam Speaker.
Has everyone recorded the vote? Does anyone care to change your vote? Not, the clerk will take the call. The amendment fails. Is there any additional amendments to the bill to its title? Gentleman from Hartford.
Thank you, Madam Speaker. I have an amendment at the desk. Amendment 893728-1.
Amendment number 1.
So much be considered the reading of the amendment.
So ordered.
Thank you, Madam Speaker. So just like the minority whip just said, this bill is significantly better than the original bill, and I'm grateful for the work of the Judiciary Committee to improve this bill. One of the parts of the bill as amended states that the court shall make notifications to the Maryland Police Training Standards Commissions for the filing of any civil action against a police officer. And as you know, people can file a civil suit for just about anything. But there's one thing that I admire about this body. Even though we disagree on it and we see it differently, the one thing that every member of this body wants is fairness. We want fairness for every Marylander. Even if we sometimes don't come to a consensus of what that is, the intent is still there. One of the things that is the hallmark of fairness is innocent until proven guilty. And unfortunately, what this bill does is state that whether guilty, not guilty, fair, unfair, justified or unjustified, this law enforcement officer's civil case must be reported to the Police Training Standards Commissions within 10 days. And not only this is unfair for law enforcement, this is unfair for the courts, because now the courts have to make this notification within 10 days. And then, how do we require the federal courts to make the notification? Because many of these civil cases are actually filed in federal court, not state court. So that's an additional hurdle. Now we're going to mandate the federal courts must report this within 10 days to the Police Training Standards Commission. I'm not sure that's even possible. So all my amendment does, it does not change the intent of the bill. All it does, it creates fairness to the court, and most importantly, fairness to the individual being charged, and give them their due process. So all my amendment seeks to do is not require the report of a civil case against law enforcement until after all proceedings have concluded, including rights to appeal. This is about fairness. It's about fairness to our law enforcement. It's about fairness to our courts. And I do not believe it changes the intent of the bill whatsoever. And I would, with that, move the amendment, Madam Speaker.
Chairman of the committee.
Thank you, Madam Speaker. I'd ask you, the body to resist the amendment. The bill is straightforward, and it's consistent with what we do with nurses, and to a degree what we do with doctors, where there is a claim brought against those groups. The claim is basically mentioned to the regulating agency, and so that's what we're doing here. We're simply saying there's been a claim made, there's been a case file, and so we at least let MPTSC know that the case is going on. They are not required to do anything more at that point. They just have the information that the case is going on, and that's why this amendment is irrelevant. Not irrelevant, it's unnecessary. I beg your pardon. It's unnecessary, and I'd ask the body to resist the amendment.
On the amendment, all in favor signify by saying aye. Opposed? Roll call.
Madam Speaker.
Has everyone recorded their vote? Does anyone care to change their vote? Clerk will take the call. The amendment fails. Are there any additional amendments to the bill to its title? Hearing none, the bill is passed to third reading.
Madam Speaker?
Yes.
Vote change, please, on Bill 430, on the last amendment for the last bill from nay to yea. Yea to nay.
Any other changes?
Madam
Yes,
Speaker.
gentleman from Harvard.
Vote change on Senate Bill 691 from yea to nay.
Madam Speaker.
Yes, that was the gentleman from Harvard. That's it? Okay. Gentleman from Harvard.
Madam Speaker, vote change SB 691 from yea to nay.
Madam Speaker.
Gentleman from Baltimore County.
Thank you. Vote change SB 290 amendment /813327/1 to nay. Thank you.
Any other vote changes? Quorum call.
Madam Speaker.
Clerk will take the call. There are 137 members present. The House is still in session. Calendar of third reading. House Bills number 99. Clerk will read the first bill.
House Bill 97, Criminal Procedure, Expungement of Records, Redeem Act of 2023.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 99 votes in the affirmative, House Bill 97, having received the constitutional majority, is declared passed. Clerk will read the next bill.
House Bill 298, State Police Retirement System and Law Enforcement Officers Pension System, Deferred Retirement Option Program, alterations.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 137 votes in the affirmative, House Bill 298, having received the constitutional majority, is declared passed. Clerk will read the next bill.
House Bill 332, Public Safety, Law Enforcement, Body-worn Cameras, Body-worn Camera Appropriation and Financing Act of 2023.
Is on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 136 votes in the affirmative, House Bill 332, having received the constitutional majority, is declared passed. Clerk will read the next bill.
House Bill 675, Commission to Study Trauma Center Funding in Maryland.
It's on third reading and final passage. Is there any debate? If not, the clerk will call the roll.
Madam Speaker?
Has everyone recorded their vote? Does anyone care to change their vote? If not, the clerk will take the call. There being 137 votes in the affirmative, House Bill 675, having received the constitutional majority, is declared passed. First bill.
Madam Speaker?
Yes.
I have a vote change or non-working finger on HB 332, like to be recorded in the green.
Get your gold slip up there. Report of the Committee on Judiciary, report number 34. Clerk will read the bill.
Senate Bill 859, Reproductive Health Protection Act, favorable.
Senate Bill, this is third reader, right? No, the second reader. It's on second reader. Yeah, wait a minute. Got too many papers here. Question for the House is the adoption of the Fable report. All in favor signify by saying aye. Opposed? The ayes have it. The Fable report is adopted. Are there any amendments to the bill to its title? Hearing none, the bill is ordered past the third reading. That ends work at the desk. Committee announcements, appropriations,
We will not meet before session tomorrow.
judiciary.
Thank you, Madam Speaker, ladies and gentlemen of the House. The House Judiciary Committee is not going to be meeting for a voting session tonight. However, watch your emails for a potential voting session in the morning.
Environment and Transportation.
Thank you, Madam Speaker. The Environment and Transportation Committee can go home. Just for one day, though.
Ways and Means.
Thank you, Madam Speaker. The Ways and Means Committee will not be meeting this evening.
Economic Matters.
Thank you, Madam Speaker. House Economic Matters Committee will be meeting tomorrow morning at 9 a.m.
Health and Government Operations.
Thank you, Madam Speaker. The Health and Government Operations will not meet tonight. However, we do have a voting session at 8 a.m., but we do have breakfast for you.
Any subcommittee announcements?
Rules.
Rules? Oh, rules, sorry.
Thank you, Madam Speaker. The House Rules Subcommittee will meet at 9:45 in the old House chamber. House Rules, 9:45 before session in the old House chamber. Thank you, Madam Speaker.
Okay. Any subcommittee announcements? Okay. Any delegation announcements? Any caucus announcements? Any personal or guest announcements? I'm sorry.
Yeah, Madam Speaker, I just wanted to once again remind that the Republican caucus will be meeting at 9 a.m. tomorrow morning in room 145.
All right. Any personal or guest announcements? Okay. Quorum call before adjournment.
Madam Speaker?
Has everyone recorded their presence? Clerk will take the call. There being 137 members present, the House is still in session, recognizing the majority leader.
Thank you, Madam Speaker. I move that the House stands adjourned until Friday, April 7th at 10 a.m. Legislative Day, March 28th.